Monopoly on Violence by Keith Ackley. Chapter 1. Rights. Like the author of No Rights, the late historian Howard Zinn was well aware of the inadequacy of words on paper to ensure the rights of citizens. In his autobiography, You Can't Be Neutral on a Moving Train, he recounts a story from his youth that helped shape his worldview. One summer day, the communist guys asked me if I wanted to go with them to a demonstration in Times Square that evening. I had never been to such a thing. I made some excuse to my parents, and a little bunch of us took the subway to Times Square. When we arrived, it was just a typical evening in Times Square. The street crowded, the lights glittering. "Where's the demonstration?" I asked my friend Leon. "Wait," he said, 10 o'clock. We continued to stroll. As the clock on the Times Tower struck 10, the scene changed. In the midst of the crowd, banners were unfurled. The people, perhaps 1,000 or more, formed into lines and carrying banners and signs, chanting slogans about peace and justice and a dozen other causes of the day. It was exciting and non-threatening. All these people were keeping to the sidewalks, not blocking traffic, walking in orderly, non-violent lines through Times Square. My friend and I were walking behind 2 women carrying a banner, and he said, "Let's relieve them." So we each took one end of the banner. What would happen next would rob him of his innocence forever. We heard the sound of sirens, and I thought there must be a fire somewhere, an accident of some kind. But then I heard screams and saw hundreds of policemen, mounted on horses and on foot, charging into the lines of marchers, smashing people with their clubs. I was astonished, bewildered. This is America, a country where, whatever its faults, people could speak, write, assemble, demonstrate without fear. It was the Constitution of the Bill of Rights. We were a democracy. As I absorbed this, as my thoughts raced, all in a few seconds, I was spun around by a very large man who seized my shoulder and hit me very hard. I only saw him as a blur. I didn't know if it was a club or a fist or a blackjack, but I was knocked unconscious. I awoke in a doorway perhaps a half hour later. It was an eerie scene I woke up to. There was no demonstration going on, no policeman in sight. My friend Leon was gone, and Times Square was filled with its usual Saturday night crowd, all as if nothing had happened, as if it were all a dream. Zinn's conclusion, free speech. Try it and the police will be there with their horses and their clubs, their guns to stop you. This is of course an exaggeration, but the message is clear. You don't have freedom of speech if the police don't like what you are saying. In other words, our right to free expression is not determined by the words of the Constitution or the decisions of the Supreme Court, but by who has the power in the immediate situation where we want to exercise our rights. Another example reaffirms this point. In the late 1970s, David Mills, an atheist activist, organized a protest demonstration against a charlatan faith healer. As Mills tells the story, "I was worried, however, about 2 potential dangers of staging a protest. First of all, the followers of this traveling faith healer were not the most sophisticated people in the world, and I was concerned that they might physically assault my friends and me as we peacefully carried our signs near the miracle rally. Second, I wanted to be extremely careful that our protest did not violate any technicality of the law, such as trespassing or blocking entrance to a public facility, for which the police might break up our demonstration. Because of these 2 fears, I did an incredibly stupid thing. I drove to the local police station to ask law enforcement authorities for information and for police protection against potential threats from religious zealots during our protest march. In total that day, I spoke with about 7 or 8 police officials, either in person or by telephone. None of them was helpful, and most of them threatened me, directly or indirectly, with violent reprisals of their own if we conducted our perfectly legal protest. Like Zinn, Mills found out that he didn't have freedom of speech because he didn't have the power. As the 19th century philosopher Max Stirner observed, my freedom becomes complete only when it is my might. Why is the freedom of the peoples a hollow word? Because the peoples have no might. Stirner believed that the rights of citizens existed only on paper because given chartered freedom is no freedom. Only the freedom one takes for himself rides with full sails. According to Stirner, there was not simply a difference in degree between self-liberation and emancipation, meaning manumission, setting free, but a difference in kind. The man who is set free is nothing but a freed man, a dog dragging a piece of chain with him. He is an unfree man in the garment of freedom, like the ass in the lion's skin. In Stirner's view, rights came from only one source. In considerations of right, the question is always asked, what or who gives me the right to it? Answer, God, love, reason, nature, humanity, etc. No, only your might, your power gives you the right. Unfortunately, or fortunately, depending on your point of view, for the citizens, the state is the sole mighty one. While it is true that if you took might, freedom would come of itself. As long as the state is around, acquiring might is easier said than done. With might out of reach, people must rely on the state's grace, and unfortunately, for them, what the state gives it can also take away. Laws are passed to protect your rights, but these laws, as Howard Zinn observed, are interpreted by lawyers and judges in a world of politics and power. As Harry Brown, an author influenced by Stirner, pointed out, these laws are uncertain, temporary safeguards at best. Laws are broken, amended, repealed, overruled, ignored, and ill-enforced. They're not very effective protectors. In desperation, Americans recite the words of the Declaration of Independence, hoping for justice. We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. In Stirner's day, people likewise resorted to what one author called rights talk. How often the sacredness of the inalienable rights of man has been held up to their foes, and some liberty or other shown and demonstrated to be a sacred right of man. Those who do that, according to Stirner, deserve to be laughed out of court, as they actually are, if it not that in truth they do, even though unconsciously, take the road that leads to the goal. They have a presentiment that if only the majority is once won for that liberty, it will also will the liberty. It will also will the liberty, and will then take that what it will have. The sacredness of the liberty and all possible proofs of this sacredness will never procure it. Lamenting and petitioning only shows beggars. Although Stirner believed that a self-owning man would not sillily oppose to Nero the sacred and wine if the tyrant does not regard the sacred, it is clear from the above passage that he didn't feel that talking about rights was either contemptible or a waste of time. On the contrary, if the goal is procuring your rights, then talking about your rights is a way to achieve the goal. You must talk about a liberty if you want to win the majority over for that liberty. Once this is accomplished, the majority will also will the liberty and will then take that what it will have. The majority will take the liberty because the Austrian economist Ludwig von Mises argued the majority has the power to do away with an unpopular government and uses this power whenever it becomes convinced that its own welfare requires it. Only then will the majority have the liberty, because as Aldous Huxley said, liberties are not given, they are taken. Freedom, however, has always been controversial. The following story from Stirner dramatizes this point. What are men to be free from then, and what not? From blind credulity, cries one. What's that? Exclaims another. All faith is blind credulity. They must become free from all faith. No, no, for God's sake. Inveighs the first again. Do not cast all faith from you, else the power of brutality breaks in. We must have the republic. A third makes himself heard, and become free from all commanding lords. There is no help in that, says a fourth. We only get a new lord then, a dominant majority. Let us rather free ourselves from the dreadful inequality. Oh, hapless equality! Already I hear your plebeian roar again. How I had dreamed so beautifully just now of a paradise of freedom, and what impotence and licentiousness now raises its wild clamor. Thus the first laments, and gets on his feet to grasp the sword again, unmeasured freedom. Soon we no longer hear anything but the clashing of the swords of the disagreeing dreamers of freedom. The hardcore punk rock band Saturine Trust spoke for many with its song, We Don't Need Freedom. We don't need freedom. Freedom is what ruined your brain. With creativity, drugs, and pain. Freedom is what let you run wild. Explain freedom to your fatherless child. We don't need freedom, do we now? Freedom preaches disobedience, idiot rebellion, false allegiance, pride, waste, lust, and greed. We're too free. We're free to obey all these comfortably. That's how will be enough for you. Plenty for me. We don't need freedom. According to the narrator of Fyodor Dostoevsky's novel Notes from the Underground, freedom is unpopular even amongst its recipients. Just try. Just give us, for example, more independence. Unite the hands of any one of us. Broaden our scope of action. Relax the tutelage over us, and why, I assure you, we shall immediately beg to be placed under tutelage again. Rights are controversial because they are not ends in themselves, but merely means to an end. Or at least, this is how people who had what Thomas Sowell called the constrained vision saw it. Quote from Thomas Sowell. The constrained vision thinks of legal boundaries within which private individuals and groups may make their own decisions, without being second-guessed by political or legal authorities as to whether those decisions are wise or foolish, noble or mean. From the standpoint of the constrained vision, the scope of those boundaries of immunity from public authority are the scope of people's rights. Although these rights, as zones of immunity from public authority, belong to individuals, their whole purpose is social, in the constrained vision. In that vision, the sacrifice of the individual for the social good has a long tradition, yet it is precisely this tradition which has consistently emphasized the importance of individual property rights, for example. The crucial benefits of property rights have been conceived as social, as permitting an economic process with greater efficiency, a social process with less strife, and a political process with more diffused power and influence than that possible under centralized political control of the economy. The beneficiaries of such processes are conceived to be the population at large, and the justification or lack of justification of property rights is made to rest on that basis. In the same way, rights of free speech are zones of immunity from public authority, without regard to whether what is said is wise or foolish, noble or mean. In two of Oliver Wendell Holmes' best-known free speech opinions on the Supreme Court, he rested his conclusion on the favor of free speech on social expediency, not on the superior rights of the individual. Making rights ends in themselves leads to what Pierre-Joseph Proudhon called a swarm of abuses. In order to grasp why this is the case, it is necessary to understand the nature of rights. In his book, Persons, Rights, and the Moral Community, philosopher Laurent Lemansky explained the nature of rights by comparing them to preferences. If you and I have opposed preferences, then we find ourselves in a conflict situation, perhaps a bitter one. Yet certain strategies short of all-out combat may present themselves as offering reasonable basis for the pursuit of a solution. If we are not fanatics, we realize one person's plans and projects can easily interfere with those of another, and that accommodation will then have to be made. This involves my recognition of you as someone to whom his own goals matter as mine, due to me, as a fellow moral agent deserving of consideration. I will try to persuade you to alter your plans on the basis of reasons which I hope will be as cogent to you as they are to me, or perhaps you will persuade me to alter my plans. Even if neither of us is willing to give way entirely, the discussion process can suggest a workable compromise that safeguards what is most central to each. Disputes of alleged right against right differ importantly from disputes of preference against preference. One who is convinced that nothing short of a right is in jeopardy will not be equally motivated to pursue a strategy of compromise. Rights stake out chunks of moral turf that others are forewarned not to trespass. The issue demands with which others the must is moral, not causal or logical, comply. It is not for nothing that we tend naturally to speak of someone standing in his rights. One who is entitled as a matter of right to some outcome is under no obligation to move away from that result in his dealings with others. They must accede to his claim rather than open a bargaining exchange in which each gives up something in order to secure something. The key sentence in this passage is, one who is entitled as a matter of right to some outcome is under no obligation to move away from that result in his dealings with others. This comment gives us valuable insight into the relationship between rights and the abuses of rights, a matter which will be discussed more thoroughly below. Another troubling attribute of rights is that they imply that certain behaviors are acceptable. Not only this, rights, if only indirectly, make claims about what is right and what is wrong. Noticing this quality of rights, Stirner became convinced that the concept of rights was a religious one. Who can ask after right if he does not occupy the religious standpoint himself? Is not right a religious concept, i.e. something sacred? When the French Revolution stamped equality as a right, it took flight into the religious domain, into the region of the sacred, of the ideal. Hence, since then, the right of the sacred, inalienable rights of man. Against the eternal rights of man, the well-earned rights of the established order are quite naturally and with equal right brought to bear, right against right, where of course one is derided by the other as wrong. Before continuing, one more perspective merits your attention. It has been said that there are no rights but property rights. The only human rights are property rights. If this is true, then in order to appreciate what rights are, you must know what it means to own property. According to the free market economist Murray Rothbard, ownership implies exclusive control and use of the goods owned, and the goods owned are known as property. Ownership is the ultimate control and direction of a resource. The owner of a property is its ultimate director. The exclusive control and use aspect of property rights can lead to undesirable outcomes. Pierre-Joseph Proudhon was well aware of this. To emphasize this point, he asked his readers to follow the following question: would it not be criminal were some islanders to repulse, in the name of property, the unfortunate victims of a shipwreck struggling to reach the shore? He commented, "The very idea of such cruelty sickens the imagination. Unfortunately for the defenders of property rights, such cruelty would be acceptable if the islanders was private property." What makes the above example even more disturbing is that it was intended to be a metaphor for how the propertied class treated the working class. The proprietor, like Robinson Crusoe on his island, wards off with pike and musket the proletaire, washed aboard by the wave of civilization and seeking to gain a foothold upon the rocks of property. "Give me work," cries he with all his might to the proprietor. "Don't drive me away. I will work for you at any price." "I do not need your services," replies the proprietor, showing the end of his pike or the barrel of his gun. "Lower my rent at least. I need my income to live upon. How can I pay you when I can get no work?" "That is your business." Then the unfortunate proletaire abandons himself to the waves, or, if he attempts to land upon the shore of property, the proprietor takes aim and kills him. The possibility of someone being killed for merely violating someone's property rights is an issue that few defenders of property rights have discussed. However, one author has discussed this topic in some detail. In an essay, he presented to his readers a scenario similar to the one concerning the shipwreck. You are standing on the balcony of a 25th story high-rise apartment when, much to your dismay, you lose your footing and fall out. Happily, in your downward descent, you manage to grab onto a flagpole protruding from the 15th floor of the balcony of another apartment, 10 floors below. Unhappily, the owner of this apartment comes out to her balcony, states that you are protesting by holding on to her flag, and demands that you let go, e.g., drop another 15 floors to your death. You protest that you only want to hand walk your way down the flagpole into her apartment and then right out of it, but she is adamant. She asks, if the flagpole hanger attempts to come into the apartment and the occupant shoots him for trespassing, under libertarianism, would the forces of law and order punish the homeowner? According to this author, under libertarianism, no, the forces of law and order would not punish the homeowner. As the author explains it, the owner is in the right and the trespasser is in the wrong. If force is used to protect property rights, even deadly force, the owner is not guilty of the violation of any illicit law. This is what happens when you take property rights to their logical conclusions. Cruelty that sickens the imagination is acceptable. This being the case, it is apparent that a system of absolute property rights is indefensible, yet such a system is defended on ostensibly rational grounds. This is a matter that we must take seriously because, as Proudhon warned, if our science of moral laws is false, it is evident that, while desiring our own good, we are accomplishing our own evil. If it is only incomplete, it may suffice for a time for our social progress, but in the long run, it will lead us into a wrong road, and will finally precipitate us into an abyss of calamities, if the idea that we form of justice and right were ill-defined. If it were imperfect, or even false, it is clear that all our legislative applications would be wrong, our institutions vicious, our politics erroneous. Consequently, there would be disorder and social chaos. For these reasons, examining the justifications for property rights is not merely an academic exercise, but literally a matter of life and death. According to Murray Rothbard, On the free and unhampered market, a man can acquire property in scarce goods as follows. 1. In the first place, each man has ownership over his own self, over his will and actions, and the manner in which he will exert his own labor. Proudhon would agree. In his book, What is Property? He wrote, "Liberty is the original condition of man. To renounce liberty is to renounce the nature of man. After that, how could we perform the acts of man? No one is obliged to do more than comply with this injunction. In the exercise of your own rights, do not encroach upon the rights of another." An injunction, which is the exact definition of liberty. It is our right to maintain our freedom. It is our duty to respect that of others. A second way, according to Rothbard, that a person can acquire property in a free society is by acquiring scarce nature-driven factors. He acquires these either by appropriating hitherto unused factors for his own use, or by receiving them as a gift from someone else, who, in the last analysis, must have appropriated them as hitherto unused factors. The issue of owning natural resources is a controversial one. Proudhon asked, how can the supplies of nature, the wealth created by providence, become private property? We want to know by what right man has appropriated wealth which he did not create, and which nature gave to him gratuitously. I do not understand that property and products it carries with it property and raw material. The burning issue, as Proudhon saw it, was the ownership of land. The significance of land ownership was noted by Alexis T. Tocqueville, a contemporary and fellow countryman of Proudhon. It is land that is the basis of an aristocracy. Giving it both roots and support, privileges by themselves are not enough, nor is birth, but only land handed down from generation to generation. There may be huge fortunes and grinding poverty in a nation, but if that wealth is not landed, one may find rich and poor, but not, using words strictly, an aristocracy. According to Proudhon, land ownership was the cause of even worse abominations. If the reader thinks it is punishing logic too far to question a nation's right of property in the territory which it possesses, I will simply remind him of the fact that at all ages the results of the fictitious right of national property have been pretensions to suzerainty. That's a weird word. Tributes, monarchical privileges, etc. Ending finally in refusals to pay taxes, insurrections, wars, and depopulations. Government ownership of land was, and still is, the cause of hardships, as Proudhon explained. The right to hunt and fish used always to be confined to lords and proprietors. Today it is leased by the government and communes to whoever can pay the license fee and the rent. To make hunting and fishing a subject of sale is to create a monopoly of air and water. What is a passport? A universal recommendation of the traveler's person, a certificate of security for himself and his property. The treasury, whose nature it is to spoil the best things, has made the passport a means of espionage and a tax. Is not this a sale of right to travel? Proudhon found it strange that anyone, even private citizens, could own land. Labor gives birth to private possession, the right in a thing. But in what thing? Evidently in the product, not in the soil. Who has a right to exact payment for the use of the soil, of this wealth, which is not man's handiwork? Who is entitled to the rent of the land? The producer of the land, without doubt. Who made the land? God. Then proprietor, retire. The land is an implement, but who made it? Did the proprietor? Did he, by the efficacious virtue of the right of property, by his moral quality infused into the soil, endow it with vigor and fertility? Exactly, there lies the monopoly of the proprietor, in the fact that though he did not make the implement, he asks pay for its use. When the Creator shall present himself and claim farm rent, we will consider the matter with him, or even when the proprietor, his pretended representative, shall exhibit his power of attorney. In Proudhon's opinion, farm rent is an extortion based solely upon fraud and violence on the one hand, and weakness and ignorance upon the other, the proprietor producing either by his hand labor nor by his implement, and receiving products in exchange for nothing, is either a parasite or a thief. One would expect such an arrangement to produce effects similar to those produced by the institution of slavery, since, like the slave owner, the proprietor receives products in exchange for nothing. Slavery, according to de Tocqueville, dishonors labor. It introduces idleness into society and therewith ignorance and pride, poverty and luxury. Ownership of land makes all this possible. How, then, can ownership of land be justified? According to Murray Rothbard, a man has the right to own product to the product of his energy, which immediately becomes his property. But as Proudhon pointed out, land is not the product of man. Insofar as the land is the product of anyone, it is the product of God himself, and is therefore God's property. Luckily, for the 6 billion and counting presently existing human beings, God does not shoot us all for trespassing on his property. Despite all this, Rothbard argues that a person can own land if certain conditions are met. The origin of all property is ultimately traceable to the appropriation of an unused nature-given factor by a man, and his mixing his labor with this natural factor to produce a capital good or a consumer's good. For when we trace back through gifts and through exchanges, we must reach a man in an unowned natural resource. In a free society, any piece of nature that has never been used is unowned and is subject to a man's ownership through his first use or mixing of his labor with this resource. In the free society that we are postulating, one would have to use the land to cultivate it in some way before he could be asserted to own it. This cultivation does not have to involve tilling the soil, although that is one possible form of cultivation. If the natural resource is land, he may clear it for a house or a pasture, or care for some plots of timber, etc. If there is more land than can be used by the limited labor supply, then the unused land must simply remain unowned until a first user arrives on the scene. Any attempt to claim a new resource that someone does not use would have to be considered invasive of the property right of whoever the first user will turn out to this purely free enterprise system is attractive, because under it there would be no such thing as a governmentally owned public domain. Land would simply remain unowned until it first came into use, after which it would be owned by the first user and his heirs, or assigns in a truly free market. For example, it would be conceivable that an Australian agency could arise, laying claim to ownership over the vast tracts of unused land on that continent, and using force to prevent people from other areas from entering and cultivating that land. Rothbard argued that problems and difficulties arise whenever the first user or first owner principle is not met, the most obvious being government ownership of land. In almost all countries, governments have laid claim to ownership of new, unused land. Governments could never own original land on the free market. Keeping land out of use raises the marginal value product and the rents of of a remaining land. Under his system, Rothbard argued rents would be lower. Rothbard's system, like most systems, has its upsides. In order to better evaluate an economic system, it is wise to look at it in terms of the incentives it creates. It is difficult to determine what the consequences of a social progress will be before it is implemented. However, some consequences seem likelier than others. As mentioned, under Rothbard's system, land becomes private property after someone mixes his labor with it. According to Rothbard, the mixing of labor with nature may take the form of draining, filling, clearing, paving, or otherwise preparing the site for use. Tilling the soil is only one possible type of use. If owning land is desirable, and draining, filling, clearing, paving, tilling, etc. is a way to own land, then people will have every incentive to drain, fill, clear, pave, till, etc. Not for the sake of producing something of value, but for the sake of owning land. Besides draining, filling, clearing, paving, and tilling, what else constitutes mixing one's labor? We've all seen beaten paths. Is this not a product? Then, does walking on the ground constitute mixing of the labor, or do you have to walk on it until a beaten path appears? If walking is not mixing your labor, then does that mean that nomadic people who have utilized the land as a right-of-way for untold centuries lose all claim to its use once the first clever farmer shows up and sprinkles some seeds? And if sprinkling seeds is mixing your labor, then do you own the land around that plant? Around the plant? If you don't own the land around the plant and someone else mixes his labor with the land around the plant, can he keep you away from your plant? According to one author, it is by imprinting one's personality on the land, in effect, that we come to own it. Does leaving tire tracks on the land constitute imprinting my personality on it? What if I design the tire tracks myself? Whatever answer is given to any of these questions will be more or less arbitrary. Rothbard studied this subject because he believed that we needed a theory of justice and property. If you had no theory of justice and property rights, how could you determine who the legitimate owner of a thing was? If you believe that whoever the existing government decrees has the property title should be considered the just owner of the property, then how would you object to the government of New York State turning over the entire territorial area of New York to the Rockefeller family, the Massachusetts legislature doing the same for the Kennedy family, and so on for each state? If this were to happen, we would be faced with a new social order in which 50 new satraps would be collecting taxes in the form of unilaterally imposed rent. Only those who have a theory of justice in the property titles that does not depend on government decree would be in the position to call those titles illegitimate.